Hello, my name is Jay Chauhan. I'm a mentor at the Angel Mentorship Group. And we have on the Facebook about 500 plus people. And anyone is welcome to join the group and see the videos and hear the lectures. We do Zoom meetings every Wednesday since the Corona period. And today's session, the subject is commercial leases, and in particular, the shopping plaza lease. And the way I'll approach the subject is to first talk about the professional responsibility of the lawyer when a lease is prepared and you report to the client on the lease. And the professional responsibility, in my view, not mentioned about admission notes, also for the solicitor's exams, does not include the negligence liability and how that can arise in a shopping plaza lease. So I'll be dealing with that subject first, and then the specifics of what is normally included in a shopping plaza lease when you have to review that for a client, and how do you relate to the client in terms of the relationship, in terms of the fees, in terms of the responsibility as to what you're undertaking to do, etc. So these issues I will be reviewing it because they're not in the admission notes. So those people who would like to learn the skills of how to launch a practice are welcome to our group and sharing our experiences. So this was a situation where one member of our group had a question of how to review the lease. So in general terms, when you first time as a young lawyer want to review a commercial lease, there will be a lot of wording, which even for a lawyer is quite formidable. So it's very important that first time around that you take your time and read the lease over a couple of times until you become familiar with the subject matters that are normally addressed in a commercial lease. Now, in terms of the professional responsibility, the most important thing to remember is when a client comes to you as a lawyer and wants you to review the lease, in their minds, it is a lot of legal wording that the client wants you to review. And if you reviewed it, it's okay with the client. Now, that particular assumption is very risky for the lawyer because the problems that can arise from negligence point of view do not come up until much after the lease is signed. So the temptation is very strong. And many clients, in my experience, want to sign the lease because it's so easy to sign. You're so anxious to start a business, and then it is easy to get into the lease, and sometimes even without a lawyer. And then the problem begins much later when something goes wrong, and then you begin to read the fine print of the lease. So first, I want to review the typical situations where you as a lawyer have to be careful about. So the first issue I want to review is a question of what do you look for in the lease and outside the lease to make sure that you fulfill your duty to the client, and what are the assumptions that the legal system makes in terms of your duty to the client in a commercial lease. Very often in a lease arrangement, an agent will negotiate the basic terms of the rental and your lease with the client, and then you are brought into the picture as a lawyer to review the actual lease itself, which may be anything from 5 pages to 25 pages long. So the offer to lease is for the lawyers to understand is an agreement between the lessor, which is the landlord, and the lessee, who is the tenant. This lease is made pursuant to the law of contract. So there are certain special arrangements for the lease, so that if you want to put it on the title, there are different requirements for the lease in the registry system and those which are in the land title system. So these arrangements and the time limits before for which you can put the lease on the title are prescribed in your rules, but I won't go through that in detail. But it's important for the lawyers to know that at least you can make your client aware. Most of the time in a smaller practice, you will not get the role of the landlord's position to draft the lease, but very likely you'll get a job to look at the lease from the point of view of the tenant. So the first thing that you should look for is to look at the offer to lease and then see the terms and study the offer to lease and make sure that the terms set out commercially in the lease by the agent or the client who agreed with the landlord to have a lease are matching with the terms that will be sitting in different places in the long lease form, which you will be given to review. So first, after review of the offer to lease and the commercial terms, you'll have to look at the lease itself to make sure that these terms are properly shown in the same manner and are consistent with each other. Now, if there's a lack of consistency, you have to keep in mind that you could be liable, because if there's a discussion between the landlord and tenant, and if any change has taken place, you should insist on that change taking place in writing. So if it is written out in terms of the rental amount, then or any other issues, then you have to make sure that what you're asked to do is the same as what you have been presented in the first offer to lease, which is a contract by itself. In some cases, the offer to lease is the only document that exists because many clients are not sophisticated enough to understand in a smaller practice. Bigger companies are quite used to the idea, so they will go to the lawyer and make sure that the lease is in proper format and there's nothing they have to worry about. But very often, the client will not even come to you, and the problem may come to you in the form of simply saying that something has gone wrong in the relationship and what can you do about it. So it can end up being a litigation issue between the landlord and the tenant if there is only an offer to lease, and you have to deal with the question of the terms that are set out in the offer. You have to make the best possible interpretation and deal with the situation of advising the client based on the possible interpretations of those wording in the offer, and then take it to litigation. So I think in the Ontario bar, there is a big divide between those who go to court and those who don't go to court. So the way that you deal with the situation in the court system is very different than the way you deal with the lease as a solicitor in the matter. But Ontario lawyers are both solicitors and barristers as well. So it is usually a solicitor's job to try to deal with the lease and a barrister's job to try to deal with the litigation issue if it comes to finding the interpretation and taking it to court. If you take it to court simply from the offer or even the actual lease, the whole concept of how you deal with the relationship with the landlord and the tenant is different, because if you are looking for example, an injunction to say that the landlord should not be interrupting in the lease arrangement, then there are many other situations that may apply, which I will not review today, because our subject today is simply dealing with the written words and how to deal with the client when he comes to you to review the wording of the lease. So having said what I did for matching the offer with the lease itself, you have to obtain these documents usually from the agent or the client who brings the offer to lease to you. And the second aspect of what you do is to look at the long form of leases, and if they have not given it to you, then you go to the landlord's lawyer. The chances are that the landlord's lawyer has hired a big law firm to prepare a standardized form of what is suitable to the landlord. And there are not too many changes that the landlord wants you to make as the lawyer of the tenant or the lessee in terms of what you see in the wording. But I'm going to review a little bit later in the meeting how to review this specific wording and what is it intended for in the lease itself, which is a relationship of contract between the landlord and the tenant. Now, when you first thing that you're doing is to read the lease. And as I said earlier, the client will very often think that if you as a lawyer have read the lease, then they don't need to worry about the complicated words, because the complicated words are simply for the lawyer to deal with and not for the tenant to deal with. So he's counting on you to read the lease, and you are then giving the opinion on different clauses. So if you do not match the expectation of the client at some future date in mind, then the problem will end up as a negligence problem for the lawyer to deal with. So you'd be important to deal with the situation in terms of what the expectation of a client would be in a lengthy worded lease where a lot of complicated wording is used to try to explain the position of the landlord. So what I suggest to our group and the lawyers to deal with is a precautionary measure of how to get the client to basically understand that it is not possible in a lease situation to set clause by clause and explain each clause to the client who may be a tenant. And therefore, you have to shift the responsibility to the tenant and the client to read the terms of the lease, which he may not read, but if he does not, you should not be stuck with the liability for a problem that can arise in the future from the wording of the lease. So what I suggest is a memo. If you can standardize the memo and explain to the client what is it that they're looking for, and if any member of our group wants to do a commercial lease and is looking for a memo, I'll be happy to send it to the lawyer in question. But having obtained an acknowledgement from the client or a letter from the lawyer to the client, you would have to then wait for the client to acknowledge that they will read the lease, and if they have a question, they will ask the question to you. What that does is to shift the responsibility for reading each clause to the client and making sure they understand it, because he will not remember after 3 years or 5 years or 10 years what is the discussion that you had with the client. So the first letter and a memo that you write to the client will explain his duty to read and ask questions to you should they not understand what is said in the lengthy wording. So I think in the memo that you write to the client, all the major issues that they should think about should be written out to them in plain language. So for example, sometimes there are situations which are not addressed in the lease, but may be important. For example, if you're in a shopping plaza, some shopping plaza will allocate certain spaces for the customers of the client who runs a business in the plaza to park their car. So if you cannot park the car properly, you will not have the customers. Now, if the subject is simply missing from the lease or offered to lease, then you will have to deal with the question, and remember to deal with the question, because even though it is not in the lease, it is an important event for the client to deal with. And the way to think about the subject of the lease is, what are the practical situations that can happen to the tenant who is your client in the future that can raise the question in their mind? That's how you should read the wording, and then how you should advise the client. And that is how you should prepare the memo to the client to make sure that those issues are addressed. And if they're addressed in the worded lease, then you can explain them in plain language, and then confirm this in the reporting letter to them at the end. So a memo plus a reporting letter are important. If you simply leave it for the client to read it, he may not read it and say to you, yes, I've read it, or he doesn't deal with the subject, and there is not enough communication between you and the client, then it poses a problem. The other problem that you have to deal with is that a smaller client who doesn't own the plaza, but you're only acting for a tenant, and he's using only one of the shops in the whole plaza, then he does not have the resources and financial wherewithal to try to pay the lawyer on an hourly rate. So very often he may ask you, then how much is it going to cost you for the lease? And then you quote a fee. And in my case, there was nothing in the biometric notes. And when I launched my own practice, I had to figure out by hit and miss as to what is a reasonable amount to charge the client. Now, one of the problems is that as you become more mature in having dealt with many leases, your hourly rate has gone up as well. And the smaller people who still come to you need to know what your fees will be. So I think it is my view that you should have some discussion on the fees. So I would say that from the client's point of view, the lease is very often described as standard lease. So the client's emphasis will be, this is standard lease, and therefore it would not take the lawyer from his experience too much time to read it, and therefore there's not too much to do, and therefore 1 or 2 hours may be sufficient for you to review the lease. But the reality of the situation is that it is not what the lease says that is the most important part. And the admission notes are written out to explain the lease and how the law of contract works, and the typical issues that you have to deal with when you deal with the lease. But it does not deal with the question of the relationship between the lawyer and the client in the lease situation. So I think in terms of the first meeting with the client may center around the question of the fees and the question of what you will do. And if you have a written memo, what you will provide to the client in terms of the written memorandum to explain what a typical lease will do. Once you create that memo from your experiences and from what you think are relevant issues, then you are ready to deal with the question of the lease and review it in terms of the wording that you have to look at and explain the key wording to the client. So I think that if you arrange a meeting with the client, in my view, it would be very useful to have the client look at the words. And if he does not look at the words, at least look at the headings and see that the client is in a position to understand what the wording says in the heading format. And then you can discuss the subject around that heading that is mentioned in the lengthy lease that is given to you to review. Now, over the years, this is the English law that was brought to Ontario. And over the years, the rights of the landlord to own the property and deal with it were complete in terms of what he wanted to do on the property, subject to bylaws of the municipality. He could do whatever he wanted to do. Now, you're transferring these rights to the tenant with the lease and anticipating many different situations, such as, for example, what would you do if the property burnt down, and many other issues which are projection into the future of what could happen and how the complicated relationship between the landlord and tenant will work. So you have to anticipate each situation and deal with the situation from the point of view of the future of what might happen in the relationship. So I think in terms of the meeting, it is very helpful to have the client read the lease, and then you have a meeting with them. And in that meeting, you highlight the issues that you think are relevant and let the client ask you the questions as to what they're concerned about and the special situation that you might encounter that may be relevant to the client. And in terms of the conclusion of the meeting, then the client may want to make changes. You might want to make changes in the lease, but you have to keep in mind that when a shopping plaza lease is created, very often it is created for the whole shopping mall. And then the variables of the individual person, such as the amount of space that the tenant is taking, may be specifically shown in a schedule attached to the back of the lengthy lease. But apart from those variables, the variables of the relationship between the landlord and tenant are described in fine print in the standardized lease version that the landlord will prepare for the shopping plaza. Because the idea of a shopping plaza is that the landlord will create a building, and then within the building, he has spent his money to create the plaza in a structure, and then asking each tenant to deal with the question of what he needs. Suppose it's a restaurant that he's building, then he will let the tenant build the restaurant. If it is a clothing store that is being put up there, then he will let the tenant build a store. The shopping plaza will set things in mind in terms of what the landlord wants to do in a shopping plaza arrangement. And therefore, from the business point of view, what the landlord is trying to do is to essentially calculate his cost of construction, the purchase of the land, is borrowed the money of the mortgage company, and then building the plaza as a structure, and then asking the tenant to do the fixtures and improvements within the property which are specific to his business. So I illustrated from the example of a restaurant and a clothing store, and these are examples, but there are many different types of stores that may be going into the shopping mall, and the role of the landlord is several-fold in a shopping plaza lease. So shopping plazas are very common in North America, and so the chances are that you'll end up with a client who will come to you in your younger practice, and if you're really expert in a big firm, then you'll end up drafting the lease also for a whole shopping plaza if you are in a big law firm. But I think for most of us, it'll be a smaller client, a person who is a tenant, and then you're looking at the lease from that point of view. So I think even from that point of view, it's very helpful for you as a lawyer to understand the perspective of the landlord and what he's going through. So I'm going to go through a few clauses in the lease to explain to you what is it that you need to deal with when you are dealing with a shopping plaza lease. So I think if you are in one building or one particular structure in which you have the tenant occupy the premises, it is much different than the shopping plaza lease, where the whole lease is standardized for the whole plaza. But in the one building, there is a better chance of your negotiating specific terms of what the client who is a tenant can do in negotiating with the landlord. So I'm going to deal with the shopping plaza in this discussion and explain some of the clauses that you might have to deal with in a shopping plaza type of a lease. So I think first issue that I'd like to discuss is explain the general idea of what is it that you might be dealing with for the client who is a tenant in terms of the leased premises. So that'll be in the beginning of the lease, where the landlord will have described in the lease that you are, as a tenant, looking at a specific area of the lease premises, which are described in a sketch or a drawing, which is attached to the back of the lease. So the lease premises are very often described by a sketch, but also by the description of the area that you will occupy as a tenant in the shopping mall. So first thing to keep in mind, which is not in the bar admission notes or explained usually in a shopping plaza lease, is the fact that what is the landlord thinking and how does he draft the lease? And that is essentially he's covering his costs of construction and separating that cost from the cost of different things of managing the plaza itself. So in the lease, you see firstly the description of the area, and then that area is being leased to you with a certain amount of rent. So the rent area, that the area that you're renting from the landlord has the entire space of quite a few feet. And then you're trying to figure out from the mathematics of the entire area and the cost of construction, the cost that you want to allocate to that particular tenant. So this particular relationship is based on the total area divided by the square foot area that is the cost to the landlord of construction, and that area will be occupied by your client, the tenant, and who will then be paying the minimum rent, and therefore they will be heading in the lease that is called the minimum rent that your client will pay to make a payment to the landlord. But this minimum rent does not cover the cost of many other situations that are going to arise in the relationship of a lease in which the landlord is looking to also manage the plaza in a different way. So let me give an illustration that there are a number of expenses that will be incurred for the landlord, such as for example, the snow clearing. And if you do that kind of service to the tenant, so cleaning up the snow in the common parking area, then the cost of the common expenses is also shared between the different tenants in the building, and it is done by a percentage rent. So you take the whole area of the lease and divide it by the area that you occupied, and you get your percentage based on that particular area that will be taken by you as the tenant, and therefore there is a percentage area on the total expenses that will be incurred by the landlord to run that particular space, and you share that expense with everybody else in the plaza. So there is in the lease typically a minimum rent arrangement and then a percentage rent arrangement. And the percentage rent is based on the services that the landlord will provide for the group as a whole. And the clearing of snow is an example of that arrangement. But to do this arrangement, it also takes the time and resources for the landlord to do that. So there would be something like a heading under the management fee that the landlord will charge. Very often this can be something like 10-15% of the amount of the total cost of running the plaza divided by the total area and multiplied by the area the tenant will occupy. And that amount for the common expenses, if you like, of running the plaza will be shared by each tenant based on the amount of space that he occupies in the shopping mall. And on top of the cost, the accounting and the management cost of running the plaza is then also shared by all the tenants in the shopping plaza by the management fee arrangement that the landlord would charge on top of that. Now, sometimes there is a particular kind of detailed accounting arrangement, which we as lawyers are not equipped to deal with. So I think it is important that where there is a complications, then you ask the client to have it reviewed by an accountant who will go through the calculations of the total cost, the sharing of the cost, the management fees, and give you a report and even negotiate for you with the landlord of the reasonableness of charging you the additional management fee and the additional cost of the percentage rent that you might have to pay to the landlord. So I think that as far as the lawyer is concerned, it is not our role as to be the accountant. Therefore, you should ask the client to have an accountant review the particular cost if required. But that is after you have started the lease and you run through 1 or 2 years of arrangement. But when you start the lease, the first question that will arise in the client's mind is that, what is the amount? In the shopping plaza is totally new, that amount is not very certain because the landlord has not matured his experience in terms of what type of cost there will be. But he will simply write a general clause to say that the cost of certain services provided by the landlord will be shared by the tenants, and he will charge a management fee to run the operation. So I think that one way you can cover the situation is that you, as a lawyer, the client is counting on you to tell the client how to deal with the wording of the lease. So you can read out the wording in which the services of the landlord may be described. But you're not in a position to try to describe each event, nor even to try to even specify the amount that may be charged to your client in terms of the fixed amount. So if a mistake happens and the amount turns out to be totally different than what the client expected, then you don't want a situation where you found to be negligent that you didn't advise the client as to what the fees might be to occupy that portion of the property, which is a small area in the total area that the landlord is managing in the plaza. Now, the other part that you have to deal with is a question of a new plaza that the landlord is trying to promote to attract the clients or the public to come to that plaza so that the different kinds of shops are there. And those different shops are going to share the cost of promoting the plaza to attract the local clients. So I think to give an example of Richmond Hill, that in the last few decades, we had the first small strip plaza in Richmond Hill, in the north part of Richmond Hill, And those principles that I described to you would apply in terms of sharing of the cost between different tenants. But then as the development of retail trade changes in the economy of the town, then you might get a bigger plaza where there is an enclosed space so that people can go in the summer and the winter, and the temperature is very regulated and made more comfortable, more expensive, and more pleasant for people to go. But you, as the lawyer advising the tenant, is in charge of trying to explain that all these other special arrangements to attract the clients are going to cost money in different ways, not only in the common expenses, but also in the launching of the site as in starting operation of the plaza, in which there will be a promotion fund required. So there will be a certain amount of percentage that the landlord will charge to the client. And the promotion fund is also another heading in the commercial lease that you will see, in which the tenant is asked to share in the cost of promotion. So the promotion fund is at the beginning of the launching of the plaza, and then later, at later date, it becomes a part of the advertising cost. So that you'll see in a typical shopping plaza lease that there is a promotion fund, and then there is an advertising cost of promoting the plaza on an ongoing basis. So I think that there are certain types of businesses that benefit more from advertising than others. So some landlords will try to adjust that particular kind of business. For example, a restaurant will be benefiting much more in terms of the advertising than other types of shops where you have other services that are available in the plaza, and therefore the percentage that you allocate may slightly be different. But very often the landlord wants to remain fair, and therefore the percentages and the advertising cost of promotion and the advertising are fixed by a percentage rate, and that you are telling the client how you can anticipate certain amount of cost in addition to minimum rent and additional rent and the cost of the promotion fund, which are all calculated and charged to the tenant. So your job is to try to explain this different cost to the tenant, and then he looks at the wording, and your job is essentially to describe the wording and not deal with the actual cost, because you don't have the knowledge nor the ability to try to be an accountant who will translate these concepts into the numeric form. So I think that coming to the next heading, which may be important to recognize for your client, may be what kind of business will he run, and is it going to be run on certain hours. So if you're, for example, a hairdressing shop within a plaza, then you will have certain hours that are typical for your business. So you have to look at those hours and see that the lease contains those hours which are desirable for your client. And you simply show the wording and explain to the client that the business will be run for that particular kind of hours in which the client is ready to operate his business. So the other part of the activities that the landlord will want you to limit yourself to is that the landlord is trying to create a certain amount of exclusivity for what you do by saying that the plaza as a whole will provide a number of different services, but he doesn't want all, for example, hairdressing shops in the whole plaza, because this wouldn't make sense. But there's a hairdressing shop, there may be a clothing store and a restaurant and different stores, which are all going to be compatible with each other. So there may be a clause restricting the tenant from doing activities other than the specific one for which he applied to become a tenant. So the wording of that particular activity is very, very important in my view, because this is a typical scenario where the landlord or the tenant, the client, can come back in the future and say, well, now I was growing my business and now I do more. So for example, in a restaurant situation, that he was serving breakfast, but instead of a breakfast, he's now doing lunch and dinners as well, and the menu may be different, but that menu clashes with another restaurant or a coffee shop in the plaza where the same kind of item is served, in that particular other premises which competes with your client's business. So the wording of the lease should be such that your client is comfortable, but you also have to bring to his attention the fact that he's going to compete with another person in the shopping plaza. So if you have to communicate, it is better that you ask the client to communicate with the landlord or the agent that is, basically dealing with the leases to see which other person is going to be occupying, and is your menu or activity as described as to what you can do in the plaza conflicting with anybody else or not. This kind of what is called a non-competition clause that you will see in different kinds of franchise arrangements also apply in the shopping plaza lease as well. So it's very important that you check on the wording of what your client can do and bring it to his attention that the wording is going to limit his activity in what he can do in the shopping plaza, and that this wording is satisfactory to him. And then when you write the report to him, it's important to reiterate also that you pointed that out to him. The other part that is a question of understanding for the clients is the repairs and maintenance clause. The basic principles of the leasing that applies to one building also applies in the shopping plaza arrangement. So in terms of the structure, the landlord will take the responsibility for maintaining the whole structure of the building and will also insure that structure. And the tenant will take the responsibility for maintaining the fixtures that he put in there in the premises. And if anything happens and if something is broken, then the inside portion of the lease and the repairs are done by the tenant, and the landlord will deal with the question of the building as a whole and structural problem, if any. So this opens up the question also as to what happens if there is a fire, for example. If there is a fire, then the insurance should take over. So there is going to be an insurance clause in the lease which will describe the responsibility of the landlord to have the insurance for the structure, and the tenant will be asked to insure the fixtures and the inside of the unit which he occupies. It is very helpful in my view, because you don't want, when the two different insurance companies dealing with one event of the fire does not get itself limited always to one premises. So if it affects the other neighbor in another common area of the plaza, you have to deal with the clause to make sure that the insurance company wrote out the insurance or what they cover in a language that does not create a conflict in the long run. So what I recommend to the clients is that you have a company, insurance company, which is the same that the landlord is using, and your client uses the same insurance company, so that the argument does not arise as to how the limitation clause will apply to your client's insurance indemnity if a fire happens. So I think that it is important in my view that once you say that to the client, this is not in, for example, this kind of information does not come from reading the admission notes. That does not explain to you in a practical sense what is it that you need to tell the client in terms of insurance clause. It is a practical issue that comes from experience or this kind of seminars in which you get to know as to how the clauses are structured and what is it that you should look for. So essentially, the point I'm making is that the landlord will insure the structure and the tenant will insure the fixtures in the premises. Now, what are fixtures? The law of the real property also should be understood by the lawyer to make sure that he explains the concept of fixtures to the client. And the fixtures are those improvements within the premises that you make, which get attached to the property and become a part of the land. The structure that you build on the land becomes a structure that becomes a part of the property of the landlord if you've not described in your lease with a clause indicating what portion of the improvement that you made within a shopping plaza belongs to your client when he leaves. So if you, for example, screw up a shelf or a freezer that is attached to the property, and if you've not said anything in the lease about it, then that particular structure attached to the land will become a part of the property of the landlord at the end of the lease term. So I think those arrangement of what is it that your client should ensure should also include the understanding of the basic obligations of the landlord to own the property as a whole and be responsible either through its own obligations or through insurance to cover the arrangement. But what you will see in those clauses is that the landlord will simply say that you are responsible, and if the question arose of a third party bringing an action for negligence, for example, then the landlord will try to limit their responsibility to only what is covered in the lease arrangement. So in terms of the clause, you have to bring it to the client's attention that the insurance clause, for example, is broad enough to cover everything you have to deal with in the event of a mishap. A fire is an example. The example typically that happens in a shopping plaza lease is that if somebody falls within the premises or in a common area, but was trying to reach your particular premises, your client's premises, and was injured. So the chances are that the lawyer acting for the injured party will bring an action against the owner of the property as well as the tenant, and then let the court decide the portion of the liability between the two. So when you draft an insurance clause, it's extremely important to bring to the client's attention the division of responsibility as well as the insurance clauses that will be compatible with the landlord's insurance as well, so that the question does not arise and the whole problem will be sorted out by the insurance company. So the insurance clauses, the responsibility of the tenant for fixtures, etc., should be understood and explained to the tenant client. Now, if the property in the insurance clause is destroyed within, and destroyed at any time by fire, what would happen? So you'll see a very detailed clause in the shopping plaza lease as to the responsibility of the landlord in the event of a fire hazard that can happen to your premises or the client's premises in the portion of the plaza. The usual clause basically will say that in the event of a fire, if the landlord cannot fix it within a time frame, very often this is 180 days, then the lease will terminate because there's nothing else he can do, and they might have to rebuild the plaza or rebuild a portion of the plaza, and he's not in a position to subsidize your client's business. And the client is now looking to survive, and the fire has taken place, and what do you do? So there's a precaution you have to tell the client, not only because of the lease, but otherwise, the lease arrangement that the client gets with insurance company of their choice should also carry a particular clause, preferably, which also will deal with the question of how will they replace the income that is generated from the running of the business that the client is doing in the premises. So that business income to business insurance clause is also relevant. Now, I think what is the duty of the lawyer is simply to point out that this clause can be put into the lease arrangement, and then is it your responsibility to look at the lease, not until they ask you to review that particular clause. So therefore, when you get a lease to review, you're not looking at insurances and anything else that may happen, which is secondary and incidental to your obligation to the client. And then if the client wants to deal with it after you advise him that it's an important clause to deal with, then you can look at it, and then you have to decide on the fees based on other things that can arise from your basic obligation to review the lease and charge accordingly the fees that you think is reasonable for the additional things that you do. Now, you have to bring to the client's attention also that he is running a business. The client is running a business, therefore something can go wrong. And if he didn't pay the rent at a particular time, then how would the relationship work? Now, the landlord in a commercial lease after 15 days has the right to re-enter the premises. Now, this particular clause is also shown in the by-admission notes to explain the rights of the landlord and the tenant. But how to make the decision on that issue is not in the by-admission notes. So the young lawyer who wants to launch a practice should know how to advise the client in terms of the obligation of the client to pay the rent and the right of the landlord to basically re-enter the premises. Now, there's a whole big long chapter that we can discuss, that if you have to end up as a lawyer to try to advise the client, how would you advise the client in terms of the right of the landlord to re-enter the premises in the event that the tenant was not able to pay the rental amount. So I think that just for your role as a lawyer, it is important that you recognize actually that what is it that you can say about the right of re-entry. So 15 days time limit, if the amount that has been paid before continues to remain the same, and there is no dispute as to the right of re-entry of the landlord to the premises of the tenant, because in theory, basically, that if the tenant does not pay the rent, the landlord can re-enter and release the premise to somebody else. If your client has got fixtures in the property and the landlord re-enters and you have no clauses to explain what happens in the event of bankruptcy of your client, then he will become the owner of the fixtures of the property and re-rent the premises to somebody else who is able to use your fixtures and then start a new business there, and your client will lose out the business. So I think that your responsibility for a new lease in a shopping plaza is to explain the situation as to what can happen. You cannot take the responsibility of what can happen and you project the financial statement of the client, and he can or may not succeed doing his business, and what will happen at the end of 1 year or 2 years. There are statistics in Canada, Ontario, that show that almost 2/3 of the new businesses very often fail. Now, when you go into a shopping plaza, the leases are drafted very much meticulously so that your client, if he fails in paying the rent, will not, will basically have to leave the premises and reconstruct his business somewhere else or stop doing the business. So I think in terms of the right of the landlord to re-enter is centered around the right of repossession of the property in the event your client cannot pay the business. So I think when you advise the client, you're not playing the accountant in advising the client. So what you're telling the client is that when you budget and create a financial statement that projects his income, revenue, and expenses, they should give a high priority to payment of rent, so that the re-entry right of the landlord does not have to be exercised by the landlord to deal with the question of your client not being able to pay the rent. So, but in a typical scenario, I think that those who want to go to a shopping plaza are much more confident that they will have the revenue. Very often they have some history, or if you have a franchise arrangement, it is much easier and more certain for ability to project the future of your revenue, of your client's revenue, because the franchisor will control the arrangement is between the franchisor and the franchisee. But in that event, you also have to be careful that the term of the franchise corresponds and has a similar date to the lease terms, so that if the lease expires and your franchise continues, what do? Very often the franchisor will also look at the lease and consent to the arrangement and the other way around. So I think that this should not be your responsibility to coordinate the two, but you should bring it across to the client that your franchise arrangement, if any, corresponds in terms of the term of the franchise, which should be similar to the term of the lease arrangement as well. So both committed at the same time. So that brings me to this point, actually. How do you renew the lease? So very often there will be a renewal clause in the lease. The leases can be anything from, let's say, in a shopping plaza type of an arrangement, 5 years to 10 years. But again, after the end of 5 years or 10 years, when the lease expires in its term, you have a right to renew. A renewal clause is similar to other commercial leases, in which the landlord usually shifts the onus to the tenant, and the tenant's obligation to precisely go by the timing set out in the wording as to when the notice to the landlord should be given to say that I renewed the lease. So when you have a lease, you bring that renewal clause to the client's attention that 5 years or 10 years from now, you will not necessarily be the lawyer of the client, but you need to bring to his attention that the client needs to deal with that clause meticulously, because if you don't follow the clause of renewal in the manner in which is set out in the lease itself, then you could be liable in negligence. So the client will say, in 5 years' time, how come you didn't tell me that this clause requires me to give a notice, for example, 6 months ahead of time? And then if you fail to give a notice, the landlord will use the opportunity to simply cancel the lease and say, well, we don't wish to renew because you didn't give us a notice. So at the time, if the values of the properties have gone up and your client did not remember the lease because he's too busy doing his business, then you missed out on the renewal clause, and that could be a major issue in the client's mind. And the first person you'll think about to sue is the lawyer, actually. So it's very important that you simply do your duty in the memo or the reporting letter to indicate that you brought to the client's attention the renewal clause and what he should do to renew the lease if he wants to renew at that particular point in time. There are usually certain other additional clauses that can affect the situation of how the landlord-tenant relationship will work if the property is held over a time limit, the lease is expired. At that time, there may be a penalty clause that will say to the tenant that in the event of the term of the lease having expired and no agreement reached for renewal, then the client is running day to day by a risk that the landlord will re-enter the premises any time and shut you down. So it's very important to understand that the renewal clause, that you have advised the client as to how the overholding clause works as well, that there may be penalties of additional rental to be paid in the event that the client has remained in the premises even beyond the term of the lease itself. So there will be an overholding clause. Now, all this very complicated language of the lease has become complicated over the years, and therefore there was a short form of Leases Act in Ontario, which applies where you do not have the wording, but you describe the lease to be in the form of the short form of Leases Act, and therefore all the terms of the short form are implied and brought into the lease arrangement. And therefore, I suggest that you also read the short forms of Leases Act to make sure whether or not that the statute applies and how it will affect the lease. Should there be a clause that is not mentioned in the lease, but may be brought into the lease in the way if you have to litigate the matter in a situation where something is not mentioned in the lease, but is brought into the lease by statute. So I think there'll be some schedules will be attached to the long lease form, such as, for example, rules and regulations of how to be in the premises. For example, how the garbage will be removed, how often it will be done, how to keep the premises clean, how the security system of the plaza will work. There will also be some details in a requirement that your client will have a certain kind of a sign on the top of your premises. So if you are writing a big sign on the top and then you want the client wants to make sure that is agreeable to the landlord, then there will be a clause in the lease also saying that the sign may be approved by the landlord, and only then you can put it up there. That also brings into the picture also the law of the trademark and the name of your client's company, incorporation, etc., which I will not review in this particular session, but these are very, very important to do. Just to give by illustration, the signs normally should be approved by the landlord, and you have to bring it to the attention of the client, because you can't just put up any sign he wants and then have the landlord accept it, especially if there is an agreement made that all the signs must be reasonably compatible. You can't have a big sign to show and advertise your premises, and the neighbor has a very small sign, and that the landlord will not like that idea because it does not make a good presentation to the public at large as to how the plaza looks and how it's presented to the public in the community. So all these things are, as you can see from the discussion, relevant, are not mentioned about admission notes. And therefore, when you start the practice, and one thing I should bring to your attention, that there is about 2,000 to 300 lawyers are graduating every year now, about half of them from local universities and the other half from NCA degrees. And then many do not get the jobs in the Corona period. About 80% will get the jobs, and some people will not get the jobs for a year or longer, and they have to probably launch their own practice. If they do, then it is very important to understand these issues and be able to make decisions on these issues. And if you can have a mentor who can help you in a small practice to make this kind of decisions, is very, very helpful. And if you do not have a mentor and you'd like to join our group is called Angel Mentorship Group. We're on the Facebook. And if this video is on the Facebook and you wish to make some comments, please do so. And I hope you enjoyed the lecture, and listen to more of them and watch them on the Facebook, or join our group on Wednesdays at noon. Thank you.